action, reiterate for me what you see as the competing interests. Somebody tell me. On the one hand, the officer's interests. On the other hand, the department's interests. What do you see? Somebody articulate those for me. Recruit Hall.
The department's interest, the workplace environment was going to not be as well because you have the lower people like against the chiefs or whatnot. It's going to be more of a hostile work environment.
Right. The department's interest is the work environment. Morale, you know, poison people, disgruntled people, bring everybody else down. Discipline, you know, paramilitary, all of that. And then what is the officer's interest? Recruit Tilly.
Just faith in the command. He asked for a union rep and the supervisor said no. When that happens, the lower, or people are lower on the scale.
No, what is his interest in the freedom of expression that he expressed?
Venting.
Yes. My gosh. I mean, we've been doing this in time memorial. Letting off steam at water coolers, at the cop bar. It can serve a very good societal good. That way people don't go postal, right? You share, you vent, you go back to work the next day. You've had this bonding experience. It's like, yeah, I know, yeah, but what are you going to do? And there's a societal interest that allows people to have these kind of personal freedom of expression shared with friends. And cops have been doing this in the locker rooms and the cop bars forever. But now that kind of personal social communication is happening on the internet. The other interest of the department is it's on the World Wide Web. So what about community trust in this agency if it gets out and you've got part of the agency pitted against the other part of the agency and gee, are these guys on the same page? Are they working together? Can the mayor still have confidence in the chief? Can the people have confidence that the department isn't? Confidence and trust because it's because of how it's being expressed, not just in the locker room where the public wasn't at risk for dealing with it. Okay. So, yes, recruit Alexander.
Quick question about number 2. On Facebook.
Well, let's do the analysis in order, okay? May we?
Yes, ma'am.
Okay. Because we're going to answer what public concern is, and we're going to answer what expressing yourself as a private citizen is. So, what's going to happen? May disciplinary action be taken against any of the posting officers, or is this protected speech? Okay, disciplinary. Now, Andy, using the Supreme Court's test for when it is so if you think disciplinary action can be taken, it's not protected by the First Amendment. Using their analysis, recruit Andy, tell me why it's not protected.
Based on what we were talking about, I don't think there's public concern. In my opinion on public concern would be something that's going to affect everybody as a whole. If he, as Recruit Barrett said, if he would have worded it maybe a little bit different to where the fact of saying how his sergeant at his department did not allow him to have a union rep, that might fall in public concern to other employees that he's friends with because it can affect...
Public means me. Not you guys. And you're absolutely right. Speaking for the taxpayers, although we don't pay tax in Alaska, but speaking for the citizens, we don't care about your morale as long as you're getting the job done. We don't care about it. We don't want to know about it. Keep your little spats and in-house opinions and fights with words like dick and scumbag to yourself. And besides, we've called our boss that any number of times too. We don't care about it. When we talk about a matter of public concern, does it affect public safety? That's what we care about. Now, I've had some people argue what I consider an attenuated, that is stretched pretty thin argument. Well, if their morale isn't good, they won't do as good a job in public safety. Too attenuated. Graft, corruption in the department, that's a matter of public concern. Dope going missing, impound stuff going missing, misuse of public funds, those kinds of things are what we're talking about. So you're absolutely right. So we're done with this scenario, right? If it's not a matter of public concern, no First Amendment protection. So let's, before we move to another scenario to get to steps 2 and other scenarios to get to steps 2 and 3, before we leave this one, what about Fourth Amendment? Right? Privacy, off-duty, privacy of your home, not on a work computer, only to people that have been friended, privacy-protected network. Let's see about Fourth Amendment. Right, I'm sorry. Because of Reno versus ACLU, we know this applies to internet postings on and off duty, just like verbal expressions. Would you read that for me, Recruit Burdick?
Yes, Fourth Amendment, the right of the people to be secured in their persons, house, papers, and effect against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause.
Okay, who does it protect the people against? Government intrusion. Now, just like with the First Amendment, and the case that expanded that to include a reasonable expectation of privacy from any government intrusion, not just searches and seizures. And we talked about that yesterday. That Supreme Court case was Katz, K-A-T-Z, in 1967. They said this creates a reasonable expectation of privacy against any government intrusion. Now, what's reasonable? Well, an expectation of privacy under the court's decision is reasonable if, first, the individual actively, subjectively expected this to remain private. Okay? And what we're going to look at is, well, what steps did they take? And a society willing to recognize that subjective expectation as reasonable. So the question becomes, for these privacy-protected social networking site, is it reasonable for you to expect something that you share with 400 people, some of whom you maybe have never met or don't know or have no control over, haven't been in contact with whoever, to remain private? That's the push-pull. And what generation do you think most judges come from? Do we have a lot of millennial-age judges? Yeah, I mean, so it's going to change. Our court rulings about what's reasonable is going to change as Gen Y people become judges. It's going to change because your view is totally different from mine. So that's when it's. So let's. So in evaluating whether the speech in scenario 1 might be protected by the Fourth Amendment, let's take a real case scenario, not unlike this, in which the court addressed expectation of privacy in a civil lawsuit. Cynthia Moreno, that's not really her because I respect her privacy. I just took a college co-ed picture off the internet. Cynthia Moreno was a college student. She, what was the name of her? Oh, she had a MySpace page back when MySpace was still holding its own with Facebook. And she came from the small town in California of Coalinga. Cynthia hated her small town. She went off to college. When she came back on her first college vacation, she decided to express her detest of her small town of Coalinga. And she wrote an ode to Coalinga, in which, as only the young can do, she expressed disdain for the small town, narrow-minded, small, little, narrow-minded people, rubes, hicks, closed-minded, all of that, in the ode to Coalinga, and she posted it on her MySpace page. She only identified, her MySpace page only, she had about a dozen friends that had ever gone to her page that she kept in touch with. And she only identified herself on the wide world web by her first name because she, didn't want her whole name out there. Her high school principal, I don't know how, he was not one of the people that had frequented her page, but it's a small town, right? He was provided a copy of the Ode to Coalinga, and he knew immediately who Cindy was. Small town, small high school, everybody knows everybody's business. But it never would have come to his attention had it not been put on the World Wide Web. He decided to share it with his friend, who was the editor of the local newspaper. They published it in the newspaper as a letter to the editor with her full name. What followed was she and her family began receiving anonymous death threats. There was a drive-by shooting into her family's home. Her family, who had had a small business in Coalinga that supported the entire family for over 20 years, had to shut the business down and move. She and her family sued the principal, the editor, and of course the newspaper. That's where the money's going to come from, the newspaper. And the cause of action was invasion of privacy. I only used my first name. I only had about 12 friends. There's no way I expected, and it was reasonable of me not to expect this to end up in the newspaper, resulting in these damages. If we have liability, people, we got probably 6, maybe 7 figures in damages easily, right? So what do you think the court did? They were the subject of a drive-by shooting. She's been outed when she never used her last name. Her family's business went down the tube and they had to move, and who knows how they're supporting themselves now. Who prevails in court? Who prevails, Dalbotton?
I would say the family does, specifically just because the newspaper could have just took that as an excerpt and posted it. They did not have to attach the name ID who actually wrote that.
Newspaper prevails. I couldn't hear you.
The editor prevailed.
The news. No, you say family prevails, newspaper prevails. How many say family prevails?
What year was this?
I've got the newspaper article on it, so it hit the media in 2009, and I'm sure it probably hit the media pretty soon after the decision. It was in the California Court of Appeals. The California Court of Appeals decision was in 2009, and I found it on the internet because of a headline in 2009. So it looks about a half and half split here. Well, here's what happened. Here's what the California Court of Appeals said. Now, they found here Cynthia publicized her opinions about Coalinga by posting the ode on myspace.com, a hugely popular internet site. Cynthia's affirmative act made her article available to any person with a computer and thus opened it to the public eye. Under these circumstances, no reasonable person would have had an expectation of privacy regarding the published material. Although the author's last name was not published on her MySpace page, her identity was easily ascertainable. And I always like to take it out of the internet context. If she, without putting even her first name, put a sandwich board on with her Ode to Coalinga printed on it and paraded up and down the town streets, would she have any expectation of privacy to the Ode to Coalinga, even though she didn't provide even her first name? Would she? Click. She put it on the World Wide Web. See, it's a no-brainer to us that the sandwich board provided no name. And because we're empathetic and we think this was awful, but her expectation of privacy is billions-fold less when she hits click. How many people are on the planet now? 9 billion? 7 billion? I don't know. 7 by such and such to be 9, and there's not going to be enough food for all of us. So my answer to all of that stuff is guns and ammo. Gold, guns, and ammo. Crazy dame. Okay, so now the court said, now here is what's left, and here's where we're going to go next. What is unclear, because she did not have any privacy protections. What is unclear, and the gray area that will continue, this is in 2009, that will continue to develop is whether publication to a select group or publication with a privacy setting activated that prevent the general public from viewing the content constitutes a waiver of privacy with respect to that. She had no privacy protections. She only had 12 friends, but they said, yeah, that's because you're just not very popular like these guys are. Only 12 people like you. It probably had to do also with MySpace building up or not building up. So what remains to be seen has now been seen. In 2011, in the case of Largent versus Reed in Pennsylvania in November of 2011, there was a civil lawsuit that involved a car wreck. So you got plaintiffs are involved in a car wreck with defendants. Plaintiffs sued defendants for serious, long-term, disabling disabilities, injuries arising out of the car wreck. Defendants asked the court to require, as part of the discovery process in the civil lawsuit, to require the court to have the court order the plaintiffs to turn over their Facebook username and password. Defendants resist. Court says, what do you expect to find on their Facebook page relevant to the lawsuit? That's the civil test. The civil discovery, and we'll look at the rule later this afternoon. Civil litigants get way more than parties in a criminal case. And this afternoon, we'll look at the difference between what they get and what is provided in a criminal prosecution. But civil litigants, private parties where the government's not involved, if they can argue to the court that what they want to look at is arguably relevant to the lawsuit, they're going to get it. They're going to be able to look at it. It may not be relevant and may not end up admissible in front of the jury deciding causation and damages, but they're going to get to look at it. And what the defendant said is, we have reason to believe, I guess, and their Facebook page was privacy protected, but stuff leaks when you have 400 friends. We have reason to believe that we would find on the Facebook page evidence relevant to their injuries, like pictures and postings about how great their gym workouts are coming along in the new Pilates class and weight training and vacations with people parasailing and things like that that might go to show their injuries aren't what they're claiming to be. So, what's the judge going to do? Mm-hmm. Yeah. But here's what he said, and the ruling has, this is Pennsylvania, not binding on Alaska. Cynthia Moreno, California Court of Appeals, not binding on Alaska. But the rulings and the rationale, other courts are going to be turning to. Remember the newspaper article where the New Hampshire judge looked at other states' rules about Fifth Amendment and what could be allowed and examined it? That's what they do. And especially in cutting area where they've never dealt with the issue before, but other states have. And just ask yourself if this judge's reasoning might apply to other might appeal to other judges. The judge in that case said this in his holding. Would you read this for me, Recruit Bohatch?
Information on Facebook is shared with third parties, and thus there is no reasonable expectation of privacy in such information.
Especially if it's 100, 200, 300, 400 people. Would you read that, Recruit Barrett?
Yes, ma'am.
He didn't say that. He didn't say fool. That was Mr. T. But he did say this.
Only the uninitiated or foolish could believe that Facebook is an online lockbox of secrets.
So, they got the password. And now that we've laid the First and Fourth Amendment groundwork, about which there is a lot of confusion on the front line, even amongst the brass who've never stopped to consider this. I got to tell you, there's a lot of law enforcement leadership that doesn't get what you got at the beginning of this class, Recruit Spears. And they can't answer those initial questions on the First and Fourth Amendment. But their response so far has all been good once I pose the question, oh yeah, if we don't know this, maybe we need to provide training on it. So, yes, sir.
Just real quick here. Facebook, Yuri says that Facebook is not, or basically just Facebook. Whereas there are different aspects about it. I'm not.
Yes,
I'm
yes,
not
yeah.
Whereas
Yeah.
I believe you can send a message to somebody specifically, like an email, kind of, and that would be different than like posting it, like so everybody can see it. So is there a difference between that? Like,
There's actual case law on emails and privacy expectations in emails in terms of whether to treat them like the letter. Do you know the Postal Service has an amazing tradition in this country? And anybody ever watched the TV show Cheers? Okay. Cliff Claiborne. I mean, you know, he thinks of himself as like Captain America. He's a mailman, but you know, in the Postal Service. But there's a history and tradition recognized by law. You put that in the envelope and seal it. You've got an expectation of privacy in that. Nobody except who you've addressed it to is allowed to look at it. And post persons will defend to the death the privacy of the mail. But here's the thing that the law also recognizes. So, en route, private, 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 private. You get my Valentine. You open it up. At that point in time, do I have a reasonable expectation of privacy over what you will do with that letter? No. I might have a expectation you will keep it private and not share it with my husband. But if you get ticked off at me and become a scorned lover and share it with my husband, a court won't recognize that as an invasion of my privacy right because I don't control. Once it gets there and it's opened by you, I can't expect to control what you will do with it. People are complex creatures, and we have good motivations and evil motivations and all kinds of scenarios and agendas, and they change minute to minute. So the law recognizes once at that point to that point, I have an expectation of privacy in the contents. And so far, absent, mass publications of emails or CCing or huge mailing lists and things like that, which may, even then, I think anything en route, and I could be proven wrong because I don't understand enough of the technology. The stuff I've looked at so far, Recruit Eccleston, is emails. So far, courts tend to afford them the same privacy they do regular mail. That's a very general, and there's going to be all kinds of exceptions with technology I don't know about, but that's kind of the general principle. And that kind of makes sense, doesn't it? Okay. So now that we've laid the groundwork for both first, yes, sir, Recruit Rubio.
Mr. Cruz, wondering, are newspapers considered social, like newspaper publishers, are they considered like social media since they get letters from people and they post stuff in their newspapers?
In terms of what way?
Well, this recruit is more referring to like the case where the newspaper place on the East Coast posted the names and addresses of concealed carry permit holders.
Oh, newspaper on the East Coast posted the names and addresses of concealed carry permit holders. I got worst case scenarios for you than that I can share with you. How about people outing undercover officers and posting their identities on the internet? And so what is your question? Can the newspaper do that?
This recruit's question more or less is, how is that not an invasion of privacy?
I don't know how they got the names. And it would depend how they got the names. Is that a matter of public record?
They were public record, ma'am.
Sorry. So sorry. That means anybody can go and look it up. And if anybody can go and look it up, newspaper can publish it. I want people knowing I'm carrying. I mean, I like carrying concealed, but I also, anybody that wants, just know at any point, right? Just know at any point in time I might be armed.
Yes, ma'am.
And I got a little thing for my sliding glass door from Gunsight that says, warning, occupants may be armed, to put on the windows and stuff of the house. Guess what I did with a Sharpie? I crossed out may, and I wrote in R, and that's around the house. If it's a matter of public record, and that's why we have to think, and that's a really good example, Recruit Rubio. Don't hide your light under the bushel. You have really good questions. Under a bush, I mean. That's a really good example of thinking beyond your publication or beyond however it's documented, to mass media. Because Cynthia Moreno did not expect it to show up in the newspaper, just even though she put it on the World Wide Web. And understanding how it can spread out there. And the fact, like the Sacramento Bee, that newspapers aren't local anymore. Newspapers aren't local anymore. This story before the internet, this story would not have probably gotten legs outside of Sacramento, maybe some in California. That's it. Instead, it's global. Very good question. Now that we've laid the framework for First and Fourth Amendment analysis, let's flesh it out, get to private concerns, balancing reasonable expectation of privacy with some more scenarios. So take a look at scenario 2. And I'm going to put the test back up here again since it was a previous slide, so you can take a look at scenario 2 and go ahead and analyze it in terms of First and Fourth Amendment.